Good afternoon. We are live. This is Ann Tomasello. I'm a Florida employment attorney, and I'm going to be answering some questions today that you have on your employment-related issues with COVID-19. So I did get a couple of questions in advance of this call, but really we're hoping that you will use this opportunity to reach out to us on Facebook and get and send us some questions, because I know that there are a lot of questions out there. And you know, there's a lot that's new and coming every single day in this area. And so we're here to help. We're here to answer your questions and to assist you in some of your concerns. I know everybody is concerned about their job, and you know, we're here to help. So we would encourage you to reach out to us. My email address is there with questions during our call if you need to be more private, or you can certainly reach out through the Facebook Live, and we will try to answer the questions that you have. So we're going to go ahead and get started with some of the questions that I got in advance. One of the questions, seeing that things are not coming through. Okay, so let's see. We're going to see, I think we're up and running now. Okay, so if I am laid off from my position, does my employer have to pay me for the time that I have already worked? The question, yes. I mean, even prior to this, your employer has an obligation under both the Federal Fair Labor Standards Act as well as the Florida Minimum Wage Act to pay you for time that you have already worked. So yes, that you do and you should reach out to an employment attorney if you are working and not getting paid, or if you have worked and have not gotten paid. Okay. Another question. I am an independent contractor. Do I get paid sick leave and expanded family and medical leave? The answer to that question is yes. You do get a credit against your self-employment tax. That's under the new federal law that passed last week. It will not start until the beginning of April, but you can get a credit against your self-employment tax, and it's based on your average daily self-employment income. So that's good news. There's also some provisions that are anticipated to come in the stimulus package that has passed the Senate and is expected to be voted on by the House and enacted by the President, but we don't know yet, so we can't answer that question for certain. Okay, another question is that we have, I work part-time. How much paid sick leave and expanded family medical leave act can I get? And that's a great question. That's a question that we hear quite a bit. So what we look at would be the average number of hours worked normally in a 2-week period. So you're gonna look back over, if it changes from week to week, we're gonna use a 6-month average. Most people have kind of a set schedule, but some people don't. And if they don't, we're going to go back and look at that 6-month average period. And so what if you worked less than 6 months? If you worked less than 6 months, then you would be looking at like the number of hours you agreed to work when you were hired. So let's say the job posting was for 30 hours a week or 25 hours a week. You would look at those numbers to see if you, to use that as a basis for your, to figure out what the, what that would be. Okay, so I am looking for questions. What other questions do you have? We're getting lots of phone calls, so I know that people have questions that need to be answered, because we are seeing a lot of people who are kind of struggling and concerned, and we share in those concerns with you. But we are here to answer your questions. You can call our offices to schedule an appointment. The telephone number in Florida is 561-653-0008. And also we have offices in California, and you can reach out to us there as well. Our website is scottwagnerlaw.com. We have a lot of good resources on our website, and we would encourage you to go there and see if you have any questions for us, to go there and we can help you with those questions as well. Let's see. So I am just going to look and see if we have questions. Right now, we are, let's see, I see, is there any protection in the law for employees who are terminated after refusing to come into work during a stay-at-home order? So the answer to that question really depends on what type of employer you work for. If you are working for an employer who is considered or deemed an essential employee who is permitted to be operating during the time, then the short answer is yes, you have to go to work. The longer answer and the more expansive answer that we really need to know further information on is, why are you refusing to come home? Or I'm sorry, come into work. And really, for that question, you would need to consult with an employment attorney in your state, because there are people who may qualify for as having retaliation if they are terminated for refusing to come into work. And so we would look at whether or not you would be in a high-risk category. For example, if you had been exposed to COVID-19 and were ordered by a doctor not to go to work or not go out in public, and you were going into work, that would violate the, public safety concerns. And so that could be an issue, and that would be something that you would want to reach out to a labor and employment attorney to discuss. Or potentially, if you're in one of those high-risk categories, you may ask your employer for time off or to work remotely in order to have a reasonable accommodation under the Americans with Disabilities Act for a condition that you may have. So under those circumstances, it depends on why you are asking for the time off or why you are refusing to come into work. That was a great question. A lot of people have that question. All right, any other questions out there? I know you have them because we are talking to people every day who are very nervous about work and this virus, and we're seeing doctors posting. One question that I get a lot is, what happens if I post on Facebook or social media that my coworkers and I don't have personal protective equipment, and we work on the front lines, and we are being asked to reuse our medical supplies. And so I post on social media and say, please help us with masks. Please help encourage your Congress people to invoke whatever protections are necessary in order for us to get this medical equipment that we need. What can I do? You know, my coworkers and I are really fearful. Well, you know, that behavior, even if you're not a part of the union, if you are acting on behalf of yourself and others in the workplace, that can be considered protected concerted activity under the National Labor Relations Act. So under those circumstances, because you are complaining on behalf of yourself and others, your employer would be probably, you know, should be concerned about taking any kind of corrective or disciplinary action against you on that basis because you posted something on social media. And if that were the case, again, we would encourage you to reach out to your local, you know, an employment attorney in your jurisdiction to see if that disciplinary action was something that probably shouldn't have happened. And so, you know, we take cases across the state of Florida. We handle these kind of cases. There are other, and in California as well. Okay, so I'm looking to see, I think that there may be a question. There's a question about notice. Do I have to give notice to my employees? So you should send out a notice to your employees in whatever way is going to be most likely to reach them. So if your employees are working remotely, the notice that you have to give under the Families First Coronavirus Response Act with regard to their rights under the paid family leave and also under the expanded Family and Medical Leave Act are notices if you have a workforce that that speaks another language as their primary language, then you probably also want to post the notice in that language as well. And the Department of Labor has issued some suggested language to use in these notices, so the employer should just take that notice and send it right out to all of their employees. They're usually pretty good about doing it in different languages as well, but you should send it in the way that the employees are most likely to get it. So if you've been communicating with your employees via email, that's a great way to send it. Also, you can post it in the workplace. You should post it in the workplace if you have employees who are still coming into work. Okay. Recommendations for how employers can track employee hours for overtime when they are working from home. And this is absolutely critical. So employers, not employees, have an obligation to track employees' hours, but that doesn't mean that the employee has no responsibility here at all. If the employer gives you a way to track hours, such as through an app or through other means, which we highly recommend that employers do, because again, it is incumbent on the employer to track the hours of its employees. These are unique times. People are transitioning to telework in a way that is not, maybe they haven't done before. And so these are, you know, I would suggest that a policy be created that talks about how employees should track hours, that talks about the fact that employees, you know, that is mindful of employees going over 40 hours a week, and that those times are tracked and that the employee signs to certify their hours when they're submitting them. And that can protect both sides down the road, both employers and employees, from certain types of claims. Okay, so what if you are an employee working overtime from home, but you're not getting paid overtime. So again, like so many questions in the law, the answer is it depends. If you are working over 40 hours a week, whether or not you are on a salary, you may still be entitled to overtime. It may change how your overtime is calculated, but unless you fall within one of the very narrow exceptions to the overtime provisions of the Fair Labor Standards Act, you would probably, a lot of people qualify for overtime compensation, even when they don't realize it. One of the things that we see a lot is employees who have a half an hour taken out of their paycheck for lunchtime, but they're never, especially now, we see all these nurses and doctors and medical professionals who are just, we are so grateful to them, who they're out there on the front lines trying to help all of us, and unfortunately they're working through their lunch and they're not getting a break. But sometimes the time clock system automatically takes a half an hour out for lunch, and that's inappropriate. Like we go back to the question we asked before, are you required to be paid overtime? Yes. The answer to that question is you have to be paid for every time that you work. If you are not being paid time and a half for, if you're an hourly employee and you're not being paid time and a half for each hour that you work over 40, you should reach out and contact an employment attorney to discuss that. You should first obviously reach out to your employer and inform them and say, I'm working all these extra hours. Can you please correct the time clock? Obviously, you want to do that first. But then after, if they're not inclined to pay you for that time that you worked and they were aware that you were working overtime, such as, they're emailing back and forth with you or sending you text messages and asking you to do work after your work hours, then, we would recommend that you reach out to an employment attorney in your jurisdiction. Okay, let's see. Another question that I see is, if my hours are reduced during the coronavirus, can I apply for unemployment? Yes, in some circumstances, a reduction in hours can result in eligibility for unemployment. And so we are still kind of waiting for some guidance in this regard. But if you are not able to work because your business is shut down and your employer is not making any money, that's the whole purpose of this new unemployment legislation that we're hoping passes very soon. It does increase, it is anticipated to increase the unemployment compensation rate to $600 a week. In Florida, it's currently $275 a week max, but it is, we are hoping that once this new law is enacted, that it will increase the unemployment compensation rate. Okay, if you are fired during the coronavirus outbreak and you have a non-compete agreement, is your non-compete agreement still enforceable? So in Florida, non-compete agreements are enforceable typically. Now, there may be things that we would look at to see whether or not your employer breached your non-compete or waived the non-compete agreement at some point. We would also ask or recommend that you speak to an employment lawyer in your jurisdiction. There are some exceptions to whether or not they're enforceable. We look at things besides and beyond just whether or not you have a non-compete agreement. I mean, if the non-compete agreement is not related to protecting a legitimate business interest, then it may not be enforceable. But again, that's something that you would want to seek out guidance from a labor and employment attorney to determine. Let's see. I am looking for more questions. If there's anybody out there who has any questions, I can go back to our I'm going to put my email address up there in case you wanted to send questions privately because you don't want to put it out there on a public forum. You are more than welcome to do so. We know that people are trying to adjust to remote work and telework, and one of the things that we would caution both employees and employers on with regard to telework is protecting personal information. That is an area that we foresee being fraught with potential pitfalls. You do have an obligation in many sectors to protect, from the healthcare perspective, and we would ask that you go back and watch our video from yesterday that's specifically for healthcare workers, to look back and make sure that you're protecting that HIPAA information. If you're in any kind of a fiduciary relationship with your clients, then you would absolutely want to go back and make sure that you're protecting that information, that anything that's being communicated be done through these secure channels, and you should, definitely consult with your IT professionals to make sure that you're doing so, because those are things that could potentially impact you down the road, both personally and in your business, and so you want to be very careful with that. Okay, let's see. If I'm furloughed, can my employer force me to use vacation time? That's a good question. First of all, what's a furlough? That's something that historically we've primarily only seen in a lot of public sector jobs. So people who work for the state or the federal government, and furlough historically has been something where you work, but then you get paid later on down the road, or a furlough essentially is that you remain on the books as an employee, but you're not working and you're not getting paid. However, you're able to retain your benefits. So if your employer, the question was, can my employer force me to use vacation time? It depends on whether your employer has a policy for vacation, or if you have an agreement, like a contract for your employment that has a specific length of time that applies to it, a specific duration. It would depend on that. And so, right now, none of the paid time off provisions of the Families First Coronavirus Response Act have even gone into effect yet. So, until the beginning of April, we won't even, no one qualifies for these paid leaves. So at this point, if you are using your paid time off, then that would, that would be, depending on the circumstances, appropriate for your employer to require that you use your own personal time off paid time off during that this window of time. It also depends on what state you're in, because there are state laws that apply. And so if you're not in Florida, you would want to reach out to an attorney in your jurisdiction. Okay, so another question we have is, my employer is a healthcare provider and I'm not comfortable coming in. Can I get family leave? Can I get sick time? Can I get unemployment? If your employer is an essential employer, as the term is defined under the executive order of the governor, then you may not have a basis to refuse to come into work. If you were terminated for doing so, you could be entitled to unemployment compensation. But since you work for a healthcare provider, you're not eligible for the sick leave, probably not eligible for the sick leave. And you only get family leave if you're home to take care of a child whose school is closed due to the coronavirus, or daycare is closed. And child is defined as anyone under 18. So if you're home to take care of your kid, you might get that extra 10 weeks under the expanded family medical leave. Okay. Another question, my employer has reduced my hours. Is that legal during this period of time, and can I get unemployment? Yes, it is legal for your employer to reduce your hours. Unfortunately, there are quite a lot of employers who just don't have work because they're unable to open during this time if they are non-essential. And so if that's the case, then yes, they can reduce your hours. Now, if you have an employment contract that says you're going to get a certain number of hours, then there are other issues that would come into play, and it would depend on your jurisdiction. I have to stay home to take care of my minor child, and my employer is refusing to allow me to work remotely. Do I get family or sick leave pay? Well, it depends. If you have a spouse who is teleworking, or a spouse who is not able to work and they are home to take care of your child, then the answer is it depends on if there's an order. But assuming that your employer is an essential employer, or they're permitted to be open right now, your employer can force you, can require you to come in. They do not have to allow you to work remotely. That's particularly true. There are some industries, obviously, that, just telework is not a possibility. If you are a server, for example, your employer can't allow you to do your job from home. Now, would it be great if they could let you do deliveries during that time, or assist with the preparation of the to-go orders and those sorts of things? Absolutely. And those are the kind of creative solutions that we're hoping, and that we are seeing on a local level here in Jupiter, Florida, that the employers are doing, that they are, trying to work with their employees. We've seen kind of tip jars out. I personally have seen tip jars out and posts that say, if you order delivery and you give a tip, the tips are going to be split amongst the staff that can't work right now. And so those are the kind of things that, that employers are doing, and, things that we like to see employers doing. But if you have a co-parent who is home with your kids, you can't require or ask that your employer let you work remotely. They are not required under the, you can ask, but they are not required under the law to allow you to do so. Okay, my employer terminated some employees and furloughed others. Is this legal? Well, yes. I mean, it depends on what employees were terminated and why certain employees were terminated, why certain employees were furloughed. They can't discriminate. They can't say, well, we're going to let go of all older employees because they're closer to retirement and we don't want them to be coming in because the consequences of COVID-19 are more severe for them. So just everybody who's older, we're going to let go, because that would violate the or potentially violate the Age Discrimination in Employment Act. The reason for you letting the employees go cannot be based on their status in a protected class, and it can't disparately impact protected classes, which would be age, race, religion, gender, national origin, disability. Now, the disability distinction is kind of interesting because it kind of comes into play in that scenario. Again, so some of these laws only apply to employers who have 15 or more employees. So we would also want to be looking toward looking at those kind of questions as well. Let's see, kind of at the end of my questions. So, all right. Well, listen, we really appreciate you listening to our Facebook Live and answering your questions. We thank you for participating. We remain available to work with you and bring you these videos to help in this time. And we invite you to go to our webpage to see the resources that we have available. And we hope that you all have a great and relaxing weekend. Take care.